Mr. Rao, and thank you to all the participants for taking the time out to join this session. The session today is on the Real Estate Act, which has been recently passed. And again, like with the earlier session, I'm not sure how many of you attended the previous session. We will try and stick to the basics, because the assumption is not that not all of us who are attending this session are either promoters or real estate agents. Some of us will probably be real estate users. Others might just be interested as compliance professionals to understand if there is a new building that is coming up for their organization, if there are any added compliances that will come in. What we are also going to talk about towards the end of the session is a new construction and demolition waste management rules which have come in case of buildings which are coming up, or in case of any demolition activity with real estate that is happening. This has come under the Environment Protection Act, and we will spend the last 10 to 15 minutes of our first 1 hour talking about that. So that is the structure of today's session. So without further ado, let's get into the Real Estate Act itself. The rationale behind the Act was that, there is a general belief, and if you look at the objects of the Act, that also talks about the fact that there is a general belief that oftentimes, obviously not all promoters, but some promoters in different parts of the country have taken, potential owners, people who have already paid money for a ride. They have not been able to deliver projects on time. In many cases, projects have never even been completed. Money has not been returned to people who have already paid up. And all of that led to the belief that there was a requirement for an act to regulate the entire real estate industry. It was also felt that in some cases, owners were not, wanted to terminate contracts or agreements to sell without any real valid reasons. So it was not always just the promoters. In some cases, it was also felt that it was the responsibility of the flat owners or plot owners to also pay up, and they did not. So keeping all of that in mind, the general belief was that the industry itself needed a proper structured regulation. Previously, some of the states, and you can see that there are some of the names mentioned, states like Haryana, Punjab, Himachal Pradesh, West Bengal, and Maharashtra had their own real estate acts. The assumption is that once the new Real Estate Act comes in, the Central Real Estate Act comes in, all of these will get repealed. The Maharashtra one has already got repealed. The others, to the best of our understanding, still exist as on today. But once the entire Real Estate Act comes into force, the assumption is that it will not, that all of those acts will subsume. Now, fundamentally, what we also understand is, what we know is that the Real Estate Act itself was officially notified on the 1st of May 2016. So the Act is actually technically in force. However, what has happened is that only the procedural provisions of the Act have been notified as on date. So provisions which will allow for the setting up of the real estate regulatory authorities, the Central Advisory Council, all of those have been notified. And currently, as we understand, most states are in the process of setting up their real estate regulatory authority, because that authority will be a state level authority. And the expectation is that, and it was stated in the Act itself, that by the end, within 6 months of the commencement of the Act, all the states are supposed to come up with the Real Estate Regulatory Authority, which effectively means that by the month of November, these authorities should be in place. And we are expecting that the substantive, substantive provisions of the Act, which actually deal with the rights and duties of promoters, real estate agents, and allottees, will actually be notified after that. So probably by the end of November or December, we should be in a position to do it. But there are some reports that we have read where there are discussions about delays. So there could be a possibility that it might get delayed by a few months. And this does have an implication from the point of view of obligations of promoters, which we'll come to in a short while. So to start with, obviously, what is important is to understand who is a promoter under the Real Estate Act. And what it says is that In case a person who constructs or converts a building into apartments or develops a plot for sale, and who sells the apartments or plots are different people. So if the developer of the entire project and the person who is selling the front end are two different sets of people, then as per the Real Estate Act, both sets of people will be considered promoters and will be equally obliged to fulfill all the compliances that are required to be fulfilled by the promoters. So this would mean so a person who constructs or causes to construct a building, a person who converts an existing building or a part therefore into an apartment. So basically, a lot of times in cities where there are a lot of existing constructions in place, you see that a existing building, maybe a two-story house or a one-story house, is broken down, demolished, and a new four-story building is constructed there. So and sometimes it's the owner of the original plot who is the front end for that entire new building. All of these people, a person who develops land into a project, any person who acts himself as a builder, colonizer, contractor, any person who constructs any building or apartment for sale to the general public will be a promoter. So beyond the point, whether you call yourself a promoter or whether you call yourself, the owner of the plot who is just selling a few floors, in the eyes of the law, that is not relevant. What is relevant, and we'll come to that in a minute, is the size of the plot and the number of flats which are being constructed for sale. Those are relevant points which we will come to in a short while. The other set of people, so there are basically who are also going to get impacted by this enactment. So apart from the promoters who are quite obviously a part of the real estate industry, the other set of people who are now going to get regulated, and this is a first, are the real estate agents. So a real estate agent, as you can see the definition here, it says any person who negotiates or acts on behalf of one person in a transaction involving a transfer of his plot, apartment or building, is in a real estate project by way of sale to another person, is a real estate agent. So it could be directly from the promoters. There could be somebody an intermediary between the promoters and the allottees. That person would be a real estate agent. A second-hand flat, an existing flat being sold, as long as there is a sale of a property from one person to the other, the intermediary will be considered to be a real estate agent. Now, the way the term has been defined, it effectively means that the online portals which have now come into play for many of these housing transactions, magicbricks.com, for example, Common Floor, all of these will technically now also become real estate agents. And as we'll see later on in this presentation, that would mean that they will also have to get registration, and that registration will not only be not be one single registration, but they will have to seek registration in each state where they're operating, which in case of all these online portals could very well be across the country. So that is the definition of the real estate agent, who are the next set of people who are regulated by this enactment. And of course there is the third set of people, which is who are the owners, the allottees, and we'll come to their rights and obligations in a little while. So essentially there are three stages in case of a promoter primarily, and we will first deal with the rights and obligations of the promoter, then we'll move to the real estate agent, and finally we'll come to the owners. In case of the promoter, essentially what happens is that they have a bunch of pre-registration formalities to complete. Once those pre-registration formalities have been completed, they are then given a username and a password. So essentially that's the pre-registration formality on the basis of which they submit their registration. Once the registration has been submitted, the authorities have a period of time. Just to clarify, every state will have its own authority, the real estate regulatory authority. So if you are constructing a project in Haryana, you will have to go and file it with the Haryana authority. If you doing the same thing in Maharashtra, then there will be an authority in Maharashtra, so on and so forth. So once you submit, you will be given a login ID and a password if your registration has been accepted. If your registration is not accepted, if it is rejected, you will be informed about it within 30 days of receiving the application. Essentially the thing is, once you get a login ID and password, there are a bunch of other compliances that you have to do on the regulatory authorities web page, and that is the third stage, and we'll come to that. So there are pre-registration requirements. Upon registration, there are a bunch of requirements, and once that has happened, you will have a set of requirements post the registration as well. So what we need to keep in mind is that it's not just about fulfilling some terms and conditions. You now also need to work very closely with the government, and for each individual project, come up with a separate real estate, a separate web page on the RERA's official website, and then continue to do additional compliances or fulfill additional requirements after that registration process is complete. So just to now get into the details of the pre-registration formalities, this is extremely critical, because this is where the whole thought process is changing. Now, if for people who have been involved in some form or the other in the real estate market, it could be as an in-house lawyer, it could be as a promoter themselves, or it could be purely as an owner. You would know that currently it is simple. You just suddenly see maybe an advertisement in a newspaper saying that there is a project happening in let's say Noida, and with some details about some artistic visuals about what the project will look like, what all facilities it will have. It might have a golf course and a swimming pool and something else, and then there are some numbers or some website ID. Email, or an email ID where you can get in touch, and then you speak to the promoters or their intermediaries, and then they tell you that this flat is, whatever, each flat is 2,500 square feet, and then they say that it's per square feet, so on and so forth. At this stage, you'll have to pay such and such amount of money. Upon completion of each of the different slabs, you'll have to pay additional money, and then at the final stage, you have to pay, say, 10% or the balance amount, whatever it may be. That's typically how the whole thing happens. There are some dates provided, and those dates are quite often quite fluid. And also what happens is you enter into an agreement cell at that stage, and then at the end, once the project is entirely complete, do you enter into the formal, the sale deed, which is then registered. This is roughly how, and I'm talking primarily about apartments, which are either flats or row houses. That's typically the process which is followed. A lot of times the promoters' credentials, whether they have been completing projects on time, what kind of whether they have already got all the land-related formalities completed, whether they've been able to get the first set of approvals that are required. None of that is necessarily out there in the open. In some cases, depending on personal equations and relationships, that information might be made available, but in many cases, that information is not available to the end user or the allottee. So. And that's one stage. And then, of course, this whole thing about 2,500 square feet or 1,500 square feet. What is 1,500 square feet is an extremely debated issue. To the promoter, 1,500 square feet can include the lift area, the lobby area, the garden area, all the common areas, and everything. And then it can all be added up and divided between the number of flats, and that's what becomes that's what gets added to what is historically known as the carpet area, for you to get to know, and then you are told that's 2,500 square feet. So, but then when you actually find out what the square feet is, it might be 70%, 60% of the actual the number mentioned. But all of that is now getting regulated in this pre-registration process. So starting with, you have to provide all the details of all the projects which have been launched by the promoter in the last 5 years, including the status of the projects, the details of any cases that have been filed, any pending payments. So a promoter, if they have launched projects which have been inordinately delayed, for which there have been consumer cases filed against them, which has historically been the way to litigate against promoters historically, all of that information will have to be provided as a part of the details of this project when you're going for your registration. Authenticated copy of approvals and commencement certificates and sanction plans and layout plans from the competent authority have to be submitted. So saying that we are still, so what happens in many cases now is that the promoters launch a project even when all the formalities with regard to the construction have not been completed, and in many cases what happens is they use that initial what is often called token money, or the advance money or whatever that they receive from different people who show interest in the property to actually go and start getting these approvals. Now all of that will have to stop. You will have to, at the point of seeking registration, give all the authenticated copies of approvals and commencement certificates. So without that, you will not even get your registration. And without the registration, you can't even advertise, as we'll figure out in a short while from now. So plan of development work, proposed facilities to be provided, including firefighting facilities, drinking water facilities, emergency evacuation services, use of renewable energy. All of these will have to be provided as a part of this registration process, and the use of renewable energy with India becoming more and more involved in the overall energy efficiency movement across the world. This will become relevant. If you go to many Western countries now, you will see that if there is a property that is being advertised, they will also say it has energy efficiency of 90%, 70%. So it will actually figure out whether it's an energy efficient building, energy efficient project. That will start happening here as well. The location details of the project with clear demarcation of land has to happen. Again, this is extremely critical because in many cases in India, both with large promoters as well as with small individual promoters, it has often been seen that after the people have started investing in the properties, they have realized that the entire land was not acquired. There are disputes over some parts. The promoter had hoped that he will be able to buy it off, but the actual process had stalled for some reason or the other. Similarly, pro forma of the allotment letter, agreement for sale. So all the documents that a promoter expects an allottee to sign will have to be submitted as a part of the registration process. And then the next one is extremely critical. They will have to mention the carpet area for the apartments for sale, which, if you see the definition of carpet area under the Real Estate Act, does not even include the balconies or open terraces, which are oftentimes a part of a building, so a part of a flat. So if you've been a part of this industry, you will know that there are oftentimes promoters who will say that okay, there's a 200 square feet terrace along with your, which is contiguous with your flat, and you have full rights, and therefore that is added to your square feet area, and we'll give you a discount on the terrace, but you will have to pay maybe 60% of the regular per square feet rate for the terrace. And verandas, of course, historically balconies and verandas have been considered a part of the flat and therefore form a part of the carpet area of the flat, but all of that has now been excluded. So carpet area is just the basic flat, the rooms, the washrooms, the kitchen, not even the veranda and the terrace, and most certainly not all the other areas, like for example, the lobby area and the lift area and the garden area, which have historically all been added up and divided between the flats. The number of garages for sale and the area for garage has also now has to be highlighted. The names and addresses of the real estate agents who are involved, the contractors, architects, structural engineer, all of that has to be a part of this entire registration process. So nothing can be kept in the dark. So you cannot say that we are still trying to figure out who the architect will be or who the structural engineer will be. All of that has to be mentioned. And if you see the definitions, it will be clear that these are all people who are certified architects, certified contractors. So you can't just mention anybody as an architect and say this person is the architect for the project. A declaration supported by an affidavit which shall be signed by the promoter or any person authorized, stating that he has a legal title to the land and the land is free from encumbrances, details of encumbrances any. So if some part of the land has not been officially transferred to the promoter at the time of seeking registration. So if it's out of the X square meters, if 10% is still not been transferred and therefore is not free from encumbrance, then that needs to be stated as a part of the registration process as well. The next part is extremely critical. People who know how promoters operate in many parts of the country will know that historically the situation has been that if you pay a promoter a certain sum upfront, the chances are that money is going to be used by the promoter to clear out dues from a previous project which is probably only 50% complete, and they will use that money to complete the previous project, and that's how they have been historically rolling the money, and that's the business model. So I'm not trying to comment on whether it's right or wrong, but that has historically been the business model for many promoters across the country. But now what is being stated is that for every individual project that a promoter is coming up with, they have to have a separate bank account, and 70% of the amounts realized for the real estate project from the allottees from time to time shall be deposited in that separate account to be maintained in a scheduled bank to cover the cost of construction and land cost, and shall be used only for that purpose. So you cannot, if a person has paid 30 lakh rupees, or you cannot take out more than 30% of that for other purposes. 70%, which is 21 lakh rupees, has to be kept in the separate account and used only for the purpose of construction of that project and nothing else. And not just that, the money once deposited into the account can only be withdrawn from that account by the promoter on completion of various stages. So if you've completed 10% of the project, you can only withdraw 10% of the money that is there in that account, and that too, it can be withdrawn only after it has been certified by an engineer, an architect, and a chartered accountant that the withdrawal is in proportion to the percentage of completion. So it's not any one of them. So a structural engineer, an architect, and a chartered accountant have to jointly certify that you have completed these slabs, and therefore that money can be withdrawn. For the next slab. So that makes it extremely difficult for a promoter to do business the way they have been historically doing. And 6 monthly audit of accounts have to be done by the chartered accountants, of these accounts, so that and obviously the chartered accountants will be under very close scrutiny. So it will not be possible for them to just certify, knowing that they also have to provide 6 monthly audit reports for these accounts. So this is making it extremely watertight for promoters, and will make the business of real estate business very different in its look and feel. They're probably a lot more corporatized. If you've been reading reports on the Real Estate Act, you'd have seen that, as you probably know, many of these larger real estate projects are actually funded by private equity funds, which are oftentimes foreign private equity funds. They are getting fairly wadded by these new regulations and their implications, and they are also going to have a much closer scrutiny of the real estate projects to be able to fund them, because otherwise they might, potentially, because of the way the definition of promoter has been created, as we discussed earlier, be considered a promoter and get into trouble if any of these projects are not following the various guidelines that have now been set up. So once the registration processes, once you have submitted all these documents and you've been provided with a login ID and password, like we mentioned in the previous slide, in slide number 5, what will happen is once you have that login ID and password, you can enter the details of the project. So all the things that you had submitted as a part of the registration process, so the details of the registration granted, quarterly up-to-date list of numbers and types of apartments or plots or garages as a case may be that have been booked, quarterly up-to-date list of approvals taken and the approvals which are pending subsequent commencement certificate, quarterly up-to-date status of the project, and such other information in documents as may be specified by the regulations made by the authority. So as we discussed, each of the states are still coming, and the regulations, the rules are still coming up, and each of the states are still coming up with their authorities. So there might be additional requirements once those come up. So essentially what will happen is, once you've applied and you've got your registration, you'll have to create a web page on the real estate authority's website for each of these projects, where the details of the project have to be mentioned, and those details have to be very clear about the number of apartments which have been sold, the status of the approvals, the status of the project, and since it will be all a part of the real estate authority's website, you will have to be very, very sure that the information being provided there is absolutely authentic. So just a few interesting things, some of which we have discussed. Now a garage has to have a roof and a wall on 3 sides for parking any vehicle. So this whole concept of open parking, which all of us have historically been aware of and been faced with across the country, goes away. So a garage has to have at least walls on 3 sides and a roof. Unenclosed or uncovered parking space such as open parking areas will not be considered as a garage. So you cannot be charging money for something, calling it a garage, if it is an open parking area. We discussed the issue of carpet area. So things like external walls, areas under service shafts, balconies, terrace areas will not be considered a part of carpet area. And the last thing is, if the person who constructs or converts a building into apartments or develops a plot for sale, and the person who sells an apartment are different persons, both will be deemed to be promoters, which of course in the Indian scenario, because of the way the market operates, becomes very relevant. So the next thing, and we've used a background of a typical real estate project advertisement. You need to be very, very cautious now when you're advertising a real estate project. You have to indicate the website address of the authority prominently. So it doesn't mean you can have your own advertisements, but the details of your registration, where you have, where exactly your project details can be found on the government RERA's website, Real Estate Regulatory Authority's website, has to be absolutely clearly mentioned. Advertisement through any medium is considered an advertisement. So even if it's an online advertisement, even if you're advertising on magicbricks.com or any of these other real estate agencies, portals, then all of those will be considered to be advertising and will fall within the ambit of advertising for the purposes of this. Advertise only those things which you intend to offer. So for example, you cannot have a mention of a swimming pool and then actually not provide one, or say that you will have a golf course and then just have a small garden. So the information that you are publishing has to be correct and true. The prospect can withdraw from the proposed project if any of the information that you provided, including any timelines that you've provided. So if you have said that the project will reach 70% completion by November, and if you have reached only 30%, then the person can withdraw the entire amount that has been paid, and compensation might also have to be paid to that to the allottee. So that's why it's extremely critical that if you are advertising a project, it is done with all the accurate details, unlike a lot of the advertisements that we see nowadays. Now, this is more in the context of where we are with the Real Estate Regulatory Authority and the Act at the moment, and it is extremely important to understand that obviously there are upcoming real estate projects. So all of those, unless there is a dramatic delay in the notification of the balance provisions, if you are a promoter, you should absolutely assume that all the conditions that we just talked about for registration will have to be fulfilled for those projects, and therefore plan those projects accordingly. Uh, Calculate the carpet area, make sure that all the approvals, etc., are already in place, because all of those will be absolutely essential for filing for registration. And without filing for registration, not a single advertisement, no raising of funds, nothing can be done. So that's one potential situation. Then there are projects where, for example, you might have finished a particular phase, but the other phases are upcoming. That's the next phase, and we'll come to each of these and explain why we're talking about that. Then where we have a situation where we have projects which have started but are far away from completion. So you might, if you're a promoter and if you have projects which are likely to be completed in, say, third quarter of 2017 or first quarter of 2018 or later, then for all of those projects, there's another scenario. And then there are projects which are, where completion certificate has already been obtained, where you've already got the project completion certificate. Then there could be another set of projects which are on the verge of completion, which might be, where your completion certificate is probably 2 months away or 3 months away. And then there is a sixth scenario, which is repair renovation work. Now we'll come to each of these. Just to give you the scenario, what the Real Estate Act has said is any project which has not received the completion certificate on the date of commencement of the Act. Now, date of commencement of the Act is the date on which the relevant provisions have been notified. So in this case, the substantive provisions have not been notified yet, but as we said, it is expected that it will be notified not too far from now. Now, any project which has not been completed on that date will have to get registered within 6 months of the commencement of the Act. For all the existing projects, therefore, if they have not received the completion certificate already, then it obviously means that you will now have to get them registered. So let's look at each of these scenarios. For upcoming real estate projects, where there is nothing which, for upcoming real estate projects which have not started at all, the assumption is that all the requirements of the Real Estate Act will have to be fulfilled for them, and therefore, as we discussed, it is extremely critical that you keep all of those things in mind and make sure that you're not just at starting to advertise a project when you have just started acquiring land. Projects which have started but are far away from completion, like we discussed. And my apologies, I mentioned 6 months, but it's actually 3 months from the date of commencement of the Act. You have to register these projects, which effectively means that if you have a project which is just, like it shows in the, you see in the picture, where just basic work has started and it's still the base has not been created, and you are definitely not going to complete the project within the next 3 to 5 months at the most, it inevitably means that these projects will have to get registered. So if you remember what we discussed during that registration process, whole lot of details need to be provided. So you need to get all the approvals immediately. You need to recalibrate all the advertisements with only accurate information. You need to make sure that the carpet area for each of these flats have been calculated and all of those details are available, and that have created a separate bank account where you have started depositing all the money that you're receiving from the project, because 70% you will have to remain in separate bank accounts. You have created all the collaterals with in terms of marketing collaterals with these informations available. You have your structural engineers, your architects, your chartered accountants in place. All of those things will take time. And if these are ongoing projects where you have already started receiving money, inevitably there will be a fair amount of additional work that you'll have to do to recalibrate the whole thing basis the requirements of the Real Estate Act, because all your projects will now have to get registered. Keep that in mind with regard to all projects which are not anywhere close to completion but have started already, for which advertisement has been set out, where money has already been received from some allottees or all allottees in the interim period. Where you're just a few steps away from receiving the completion certificate, if you are in a position to complete it in the next couple of months and get the completion certificate ahead of that, then you should obviously go ahead and do that, because then you will be able to stay away from having to register these projects under the Real Estate Act. If you do not get the completion certificate, you will have to register the project within 3 months of the commencement of those provisions. If the project is being developed in a phase-wise manner, for all the phases where you haven't yet received the completion certificate, at the time of notification of the rest of the provisions of the RERA, you will have to go ahead and get your registration for those phases. So even if you've got the completion certificate for one phase and people are staying there, for the balance phases, you will still have to go ahead and get the registration done under the Real Estate Act. Where you've already got your completion certificate, this is from a promoter's perspective, of course, is a good situation to be in, because there are no further requirements for registration. If a project is only with regard to renovation or repair or redevelopment in a real estate project where no additional buying or selling is happening. So for example, if an existing project, the promoters are building an extra set of rooms on one side for all the existing owners of flats, and there is no additional new allotments or selling happening, then in those cases there is no registration required. But it has to be very clear that it's only if an existing project is being renovated or remodeled where existing users will get whatever additional benefits are being provided, and it has no new allottees are coming into play, then there is no registration requirement under the Real Estate Act. So this is something that we have already discussed. From the real estate projects perspective, you need to get prior registration from the State Real Estate Regulatory Authority. Currently the requirement is only for properties which are more than 500 square meters in terms of size, and where there are more than 8 flats, inclusive of all the phases. But we need to remember that this number can be reduced by individual state governments. Therefore, as of now, this 500 square meters and 8 flats is an important piece of information. But as we move into the individual states notifying their respective rules, we might see changes to this, and a smaller number can also come up. In case the real estate project is to be developed in phases, every phase will be considered a standalone real estate project. So each of them have to be separately registered. All the approvals have to be separately provided. Just because you've got approvals for one phase and registered, it doesn't mean that your registration is done for the remaining phases as well. So if at a recent conference where we were on a real estate conference where we had a number of promoters present, what they all thought was that this phase-wise development will probably come to an end once this Real Estate Act is fully enforced, because it will not make commercial sense to then go ahead and get separate registrations, separate approvals, and also separate advertisements for these various phases. And they will probably this will probably see the end of these phase-wise projects which have historically been happening. Now coming to the real estate agents, which is a set of people who are, in many cases, there are, of course, individual states and as well as central real estate agents, committees, associations who are fairly active. But this is for the first time that real estate agents, if they have to be involved in the process of buying and selling of properties, whether they are existing or new properties, will have to register themselves as real estate agents, and that registration has to be at a state level, because there will be, each state will have its own real estate regulatory authority. So at each state, so if you have there are many large international agencies which are in the business of selling or brokering projects, so they will have to register in each of these states separately, and the validity of the registration will be for that state and union territory. And what needs to be remembered is that, therefore, like we mentioned, companies like Magic Bricks and Common Floor which operates you through the help in the facilitate in buying and selling properties through their portal, might potentially, as the things are structured at the moment, also have to get registration in each of the states where people are allowed to advertise their properties through their portal. And that makes it quite interesting to try and regulate, like we've seen in other cases, regulating e-portals like Uber, Ola, etc. There's always a contentious issue. So this is likely to be contentious as well once the rules are in place. The real estate agent now has clearly defined roles and responsibilities while buying and selling. For example, they cannot get involved in the buying or facilitation of buying and selling of properties in unregistered projects. So they will be looked at as the facilitators, and they will have to face penal consequences if things that a property which they have sold is unregistered, or if the commitments made with regard to that property are not met. So this is just a reiteration of what we have just said about real estate agents. You have to obtain a registration from a real estate regulatory authority for facilitating sale, purchase in a registered real estate project. Facilitate the possession of all the information and documents as the allottee is entitled to at the time of booking of any plot. Do not indulge in any unfair trade practices, such as making any statement which falsely represents the promoter's standards of services, etc. Do not facilitate the sale or purchase of any plot, apartment, or building in real estate project which is not registered with the authority. So we have seen the mushrooming of real estate agents over the years. Many of them do not have any basic knowledge of the real estate market. They just come in and they know of a flat which is being sold, and they just come and offer it to you, and you pay them a brokerage at the end of it. All of that will now get regulated by this Real Estate Act. Now, coming to the rights and duties of the allottees. So I'm obviously not fully aware of the composition of today's participants, but I'll assume that at least some of you are not directly involved in either promoting or as real estate agents. But I'm sure at some stage or the other you would be an allottee of some plot or the other. Now, as far as the rights are concerned, you can obtain information relating to sanction plans, layout plans, along with the specifications approved by the relevant authorities. You can know stage-wise time schedules of completion of the project, including provision of water, sanitation, electricity, etc. You can claim the possession of an apartment, plot, or building, as the case may be. And the association of allottees shall be entitled to claim the possession of common areas. The other thing is that if the promoters, for example, want to make any changes to the property, they need to get the approval of 60% of all the allottees, and they cannot just go ahead and start adding floors or adding new buildings inside a premise without their approval. As far as duties are concerned, it's primarily related to payment. The payments have to be made as per the schedule and as per the timeline set. Otherwise, the property can be claimed back by the promoter. But the rights and the powers for the allottee are significantly more than what they have currently. They can ask for return of money if if the project is not happening on time. They can ask for interest. And this long drawn battles that have historically had to happen through consumer courts, and then subsequently the more the high courts and Supreme Court will hopefully get reduced once the Real Estate Act and the Real Estate Regulatory Authority comes into play fully. As far as the penalties on the promoters are concerned, if they fail to register the property, penalty of up to 10% of the estimated cost of the project. And if they continue to violate, it may lead to imprisonment, which can be up to 3 years. For providing false information, the penalty is up to 5% of the estimated cost of real estate project. And again, these projects, as you know, in many cases run into hundreds of crores in terms of estimated value, and therefore 5% and 10% could be very large numbers. For any other contravention apart from registration, penalty can be up to 5%. And upon failing to follow the orders and directions of the authorities, again, there could be a penalty of up to 5% of the property value. For a real estate agent, if they fail to register themselves and continue to work as a real estate agent for every day when they are not a real estate agent officially and are doing the work, they will have to pay a penalty of 10,000 rupees. So effectively, if you start, at the moment these provisions are notified, if you do not register immediately, you could potentially have to pay just for 1 month, 3 lakh rupees as penalty. And this can extend up to 5% of the cost of all the projects. And then, of course, on failing to comply with the orders or directions, again, a 5% penalty can have to be paid. Similarly, with allottees, if they are not paying their dues on time, then they are also liable to pay a penalty for the period during which such default continues, which may cumulatively extend up to 5% of the value of the plot or apartment or building cost. So with this, we come to the end of the session on Real Estate Act, and then we have a session, a smaller session on the construction and demolition waste management rules. But what we can do, and Mr. Rao, I leave it to your judgment. We can take all the questions on the Real Estate Act first, and then move to this, or we can go directly to this. So, Mr. Rao, I will wait for your decision on that.